All right, guys. Hey, it's Attorney Edward Littlejohn, and I'm here for our newest edition of Ask Ed Live. That's right, where I'm going to answer one real estate and probate question for the group. Today, we might get a couple other questions, so we'll just play it by ear. But the goal is to help both executors, administrators, trustees, powers attorneys understand the basics of what they have to do and what they don't have to do and what their legal responsibilities and obligations are. Today I have with me Skylar. She's our summer intern and she'll be sitting in on today's call. So for those who don't know, I'm a real estate and probate attorney. I own the Ohio real estate and probate law firm, Littlejohn Law. We focus on real estate and probate matters and we handle cases throughout the entire state. Today's question comes from Ruth. And Ruth wants to know what happens when someone dies and they own a business. Can the executor or the administrator carry on the business? Well, the interesting thing about this is that when someone dies and they do own a business, the administrator can carry on the business. Typically, what we look for is what is the legal entity, okay? Is this a sole proprietorship, LLC, a limited liability company, a limited partnership, or corporation? Are there more than one members in the limited liability company that could carry on the business? Or is this truly a sole proprietorship? Under the Ohio Revised Code, the way it works is if it is truly a sole proprietorship, which means there's only one person who owns the business, then an administrator or an executor can carry on the business for 4 months without the probate court's permission. Beyond that 4-month period, they have to seek permission or leave from the probate court to carry on the business. However, if it is a limited liability company that has multiple members, or it is a corporation that has multiple members, then the administrator or the executor cannot carry on the business. Let me repeat that. The administrator or executor cannot carry on the business, but rather the other members or shareholders, it's their responsibility to carry on the business. So from time to time, our clients have these similar issues. And one of them that's recently come up is with a medical practice. And the issue that arose is a doctor gave his wife his shares in the company. He passed away and he was a part of a medical association. So the issue that arose was, is the wife able to carry on the business? Now, we know the wife does not have a medical license. So in that regard, she could not. However, she retains all of his voting rights as a voting member of the company. So she owns the shares to the company and can vote. Now, the nuance to all of that is today she can't vote because the shares are still her deceased husband's shares. That's right. The shares belong to the estate, not to the person. So once the probate court transfers those shares to the wife, then she'll be able to exercise all of her voting rights. In the meantime, if there's any dividends or anything that he's legally entitled to, he will receive that. Well, I should say his estate would receive that. She wouldn't receive it, but the estate would receive it. So if you have any other real estate or probate questions, give us a call at 740-346-2899 or send us an email to office@littlejohnlawllc.com. And remember, we're here to help you build it, protect it, and preserve it. And where there's a will, there's a way. And where there's no will, then there's probate.